Hi everyone, welcome to another video. Now, just come back from a trip to Christchurch. Sunny, beautiful Christchurch, getting a little bit cold in the winter. Went to visit a few clients and I had some thoughts about work visas and what's going on. So I thought I'd make another video just to go through some of these topics, specifically what's happening with work visas at the moment, what's happening in this post-COVID labour market. So I recorded a few thoughts while walking around and checking out the scenery in Christchurch. We're going to flip to that video in a second. But guys, stick to the end because I also have a talk about some of the potential changes that are coming through and what I think about these changes and how it might affect you. So as usual, like, subscribe and all that stuff, share the video with your friends, and if you feel like you have any specific questions you want to get in touch with us, feel free to get in touch. advice@iclegal.co.nz. Alright, let's flip to the video. Christchurch, New Zealand. Home of the Avon River, second or third largest city in New Zealand, depending on who you ask and when you ask them. Standing here at the end of the Cashel Street Mall, and today just want to have a chat about some of the changes in work visas and what's going on with work visas in New Zealand at the moment. Christchurch is a beautiful city, filled with a lot of nice architecture. I'm here at the beautiful Hagley Park. The ducks approve. Come down here to Christchurch to meet with a few clients, and I just thought it's a very appropriate place to discuss immigration matters because you might not think it, but Christchurch is really a city of migrants. It's just that 4 or 5 generations old now. Many of the Christchurch, or Cantabrians as they're called, often discuss, coming from the first boats or which family they're from. There's old European architecture everywhere representing the migration from Europe, from England particularly. And then of course Christchurch has been massively influenced by the large number of migrants who have come in to assist with the Christchurch rebuild, the earthquake rebuild, from the devastating earthquake of 2011. And of course many people will remember the terrible mosque attack from last, I think it's a little bit over a year ago now, where a gunman, unfortunately racially charged, murdered a number of Muslims while praying. And so you'll find that the discussion about immigration here in Christchurch is often quite balanced and a little bit less emotionally charged than in other areas of the country. So talking about work visas, and in particular work visas where a labour market test is required, there are some quite interesting developments going on. Now, anybody who's submitted an application under essential skills prior to the COVID-19 lockdown has probably by now, or will very shortly, receive some correspondence from immigration regarding the post-COVID labour market situation. And we've received this letter. It's essentially a template letter or email for almost every one of our clients, especially those in the hospitality, retail industries. And essentially what this letter says is that INZ is not quite satisfied that there are no New Zealanders still unavailable for the positions. And we've had a lot of questions from our clients asking, well, what do we do? How do we prove this? Immigration hasn't specifically asked us to re-advertise the position. So what do we do? What do we do? And it's quite a tough thing to answer, because in some cases an employer may be able to satisfy immigration without advertising again, or perhaps they have been advertising. And so I guess I just wanted to have a chat about some of the scenarios that work or don't work, and and what I think is the right way to go about it. Because if you've applied by yourself or with an advisor or lawyer, it's a very confusing time, it's a very stressful time, and immigration has given a little bit of a longer deadline on these responses than they normally would have. But still, when you're coming up to your visa expiry or something's going wrong, you want to know what to do and how to beat it. So as we go deep into the forest in the middle of Hagley Park here, let's go deeper into this question of how do we address these concerns coming up from immigration about labour market test and advertising. And really the question is, well, hey, do I need to advertise again? And what's going to happen if I do? Well, you sort of have to think about a few things. What's the skill level of the position? If you've got a position that you're trying to get a visa for, which is reasonably high level of skill, and you still think that there really won't be many New Zealanders available, there's absolutely nothing wrong with just, placing another advertisement for a couple of weeks and then recording, as you will have done before, recording your attempts, your engagement with those people who apply for the job, or your employer's engagement with them, and demonstrating to immigration in the same way that there's still no one available. If instead you have a position which may be nonetheless skilled, however, maybe in the hospitality or retail sector where a number of people have lost their jobs, and perhaps even your employer has had to make people redundant or is no longer fully financially sustainable, then you're going to have a serious think about this, because once you advertise, you will receive a number of candidates applying for the position, and in theory, in practice, if any of those people are suitable for the job, they have the right qualifications or experience, and who are New Zealanders, then your employer is actually supposed to be offering the job to them instead, or finding someone they can train up for the position. And so in a case where that has happened, or that's your level of position, what can we do to really answer it? Well, there are a few legal arguments that me and my team, that we're preparing, relating to fairness and natural justice, also relating to what we call the employer's case. Your employer can make their case as to why they need you and why they can't just pick up someone else. And I'll give you the example in the hospitality and retail sector, and that is that there are a lot of New Zealanders who may have lost their job in positions such as cabin crew for airlines, or let's say they've lost their jobs overseas. Maybe they worked in hotels, large chains, and they've come back to New Zealand, or they've come back to their hometown, and they're now looking for something to tide them over, let's say. Now, from the employer's point of view, it's not so easy to just hire one of these people who you can, by looking at their CV and their background, you can almost immediately assume that a lot of these candidates won't stay in the job. They may stick at it for 5-6 months while they tide themselves over, earn a little bit of pocket money, and then there's a chance that they might just keep looking for something better, or head back overseas or something like that. So from the employer's point of view, it may not seem fair to be forced to hire someone who's overqualified and who won't stay in the job. However, the danger is, of course, that if you simply claim that, then you're just making a judgment without really knowing, aren't you? The employer can't say for sure that someone's not suitable unless they try them out. It's not really fair just to make that claim. But this is one of the things that your employer can do to support you, to really make their case, not just as to why you are the best for the job, but why the other people who have applied may not be suitable. And that's really the key point. It's not so much about whether you are the right one, it's about whether they are the wrong ones. Now, with that in mind, another thing that's very important is when you list the position, make sure that your employer really notes down in the advertisement what the actual requirements for the job are. And now keep in mind that things like, let's say, for example, if the employer is a speaker of another language, and they can't actually make that language a requirement of the job unless the job itself requires that language, for example, as a translator or interpreter. If you're working as a cafe manager and your employer is, let's say a French speaker, well, you can't advertise for a French speaker just because the employer would prefer one. But you can note down things like must be available to work on weekends, must be available for flexible shifts, evenings, must hold a food controller qualification, license controller qualification, must have a certain amount, let's say 6 months or 12 months experience in a similar specialist cafe environment, these types of things. Now, it's got to be reasonable, has to be reasonable, and they have to be genuine requirements for the job. But this is what I would advise to place in the advertisements, because once you narrow down the actual requirements, you will receive a fewer number of applications, and you'll be able to reject those that don't meet those requirements quite easily and reasonably as well. And immigration would have to accept that if you require for your if your employer in that business requires someone who can lift heavy boxes, well, then if you get someone along who says they recently had a hernia operation and can't do any heavy lifting, then of course that person is not suitable. And that's really the point, whether there are suitable New Zealanders available for the job. Now, many of you have asked us, has anyone actually received a visa after getting one of these letters? And the answer is yes. Now, you have to be a bit careful about giving everyone too much hope, because it's a yes, but under the right circumstances. I'll give you the example of where we've seen approvals. It's where an employer can very quickly and promptly show immigration that they have maintained ongoing recruitment attempts and that they genuinely still need this person. And one of the examples is where someone has been, say a technician. I won't say too much about this person's particular job, but let's say that they're a technician in the company that contracts out the work, and the company actually still needs 2 or 3 others, and they have been advertising for those roles and they can't fill them, and they've had trouble filling them even before the lockdown and after the lockdown, and they've shown this to immigration very quickly, and they've had a visa approved for the applicant very quickly. So look, if you're in that position where your employer can genuinely show that, there's no need to wait for a month to reply to this letter. Quickly get in touch with them and just tell them, say, hey, look, we really do need this person and here are the reasons why. And immigration officers are going to consider the employer's situation and their current and past attempts. If instead your employer has not advertised for anything recently, and maybe they've made someone redundant recently in similar positions, you may have some difficulty, and I think that's when you really need to start talking to a professional to see if there's a way that you can help to address this properly. So I won't make this video too long, really just wanted to show you guys some of the beautiful scenery down here in Christchurch while I'm here, but I do want to just quickly mention about some big changes that are coming, and rumours of changes and actual policy changes that are coming, and this is quite important for a lot of people. We've touched on this earlier, and previously I've said, hey, we're not sure if this is going to be delayed or if it's coming through as planned. But the word on the street is that these big work visa changes that were announced last year and that were meant to be coming into force middle of this year are still going ahead, and very likely or possibly this will happen quite soon, and we may hear an announcement about it very soon, and as early as next month, July 2020, we may have some information about what is actually going to happen and when it's going to happen. Now, the key takeaway from the change is that all of the current visa categories for work visas are essentially going to be merged into one, and they're going to be segregated rather than by different names and types. They'll be segregated by the different regions of New Zealand, levels of pay, and labour market testing. Essentially. So what this means for a lot of people is that if you're going to move out of the cities and into the regions, you may actually not even need to advertise the position if you have a certain level of pay. And the understanding that we have is that if you're receiving the median income, which is currently $25.50, then and then you have a job offer which is in one of these regions, let's say Manawatu or Bay of Plenty, for example. There's a list you can find. Then you'd be eligible for a 3-year visa. And if you're in the cities, Auckland, Wellington, Christchurch, then you're competing with everyone else, and you'll need to labour market test the position, which means advertising. And when the pay rate is a little bit lower, it might be what they call a strengthened labour market test, which will likely also include work and income support. Meaning a skills match report or something like that from work and income to prove that there are no New Zealanders. Now, I think a lot of people are going to benefit from this, but there's also going to be different types of concerns coming up. All of a sudden, everyone's going to get a pay rise to $25.50 and claim to be eligible, and immigration will find other ways to be concerned about the application. For example, they may start asking for evidence that it is a genuine position and that it's a genuine pay. And that it's within the market rate for that similar types of positions. So let's say you're working as a cleaner, and you say, well, this is great, I can go for $25.50 and I'll get a 3-year visa. Well, it's possible that an immigration officer may ask, hey, why is this cleaner getting paid $25.50 when in your company all the other cleaners are getting $20 an hour, for example, or when the industry average is is different or lower. So this is something you all have to be careful. It's not simply the case that you can just make yourself eligible by grabbing a pay rise. Immigration is very careful about making sure that there's no, let's say, untoward behaviour going behind. Now, another thing to know about this visa change is that what immigration is trying to do is to remove the assessment of skill from work visas and link the length of the visa solely to the rate of pay that you receive. So whereas previously someone may have received a 3-year visa under the mid-skill band, and then they go ahead and apply for residence based on that position, and then if the residence application is not approved, they complain and say, hold on a second, you gave me my 3-year mid-skilled visa and now you're claiming that I'm not skilled at residence. What's going on here? This is not consistent. So now what will happen is you may get that 3-year mid-skill visa, but because there's no assessment of skill level, there's no sort of, I guess you can say, there's no kind of right to assume that you would be therefore eligible for residence. When it comes to residence, they're still going to assess the position, they're still going to assess your skill level, pay rate, and all of those things. So it's a little bit of a double-edged sword. On the one hand, it might be easier for some people to get a work visa, and on the other hand, it may just mean that more and more people are stuck on temporary visas without a chance to convert into residence. And those are my thoughts anyway.